Your attention, please. Welcome to the Constitutional Court. Please take note that in terms of emergency, you will evacuate the place or the court chamber towards reception, and security will lead you to the emergency door to be on the safe place. In terms of ablution facilities, you also evacuate the place to the foyer. Security will guide you where is the bathroom. Court is about to start. Please make sure that you switch off your cell phone, please. Please ensure that your cell phone is on silence. Thank you.
And the matter of Credit Suisse Securities USA LLC and Competition Commission of South Africa, and the matter of Competition Commission of South Africa and Bank of America Europe Designated Activity Company and others for hearing.
Deputy Chief Justice and members of the
Securities USA LLC.
On behalf of the Competition Commission, on behalf together with Ms. Hop, Ms. Zigalala, Ms. Drake, Mr. Ngumalo, and Mr. Monareng, we are instructed by Nzabanzaba attorneys.
Deputy Chief Justice, Justice of the Court, I appear on behalf of the 1st, 20th, and 21st respondents, which are referred to collectively as the Bank of America respondents. And I appear together with my learned friends, Mr. Nkongo and Mr. Mbakiwa, and we're instructed by Weber Wenzel. And just to make it clear, that's in case number 30/2024, the Commission's appeal, application for leave to appeal.
Deputy Chief Justice, I appear for the second respondent, BNP Paribas, together with my learned friend, Mr. Mohammed.
Thank you, Mr. Campbell.
Deputy Chief Justice, Justices of the Court, I appear on behalf of the third and fourth respondents. Mr. van der Nest, who is leading me and is on the heads, is not here today. I'm on my own.
Thanks a lot.
May it please the Court, I appear on behalf of the fifth respondent with my learned junior, Ms. Maharaj Pillay, instructed by CDH Legal.
Thank you, Mr. Loxton.
Deputy Chief Justice, members of the Court, I appear with my learned friend, Mr. Mokoena, for the eighth respondent, Standard Bank of America, in the Commission's application for leave to appeal, and we do so on the instructions of Herbert Smith Freehills.
Thank you very much.
Deputy Chief Justice, Justices, I appear on behalf of the 9th respondent, Numera. Mr. Butler, who is leading me, is not in court today, instructed by MGI Competition Law.
Thank you.
Good morning, Chief Justice, Justices. I appear for Commerce Bank, the 12th respondent, with Ms. Williams, instructed by Weber Wenzel.
Thank you.
Deputy Chief Justice, members of the court, I appear for the 13th respondent, Macquarie Bank Limited, together with my learned friend Ms. Bosman, instructed by Bowman Gilfillan.
Thank you.
May it please the court, Deputy Chief Justice, I appear for the 14th respondent and also the 19th respondent, together with my learned friend Ms. Avidon.
Thank you. Well, I don't think that completes the lineup, unless you want to tell us something else.
Deputy Chief Justice and Justices of the Court, I appear for the 25th respondent, the Nedbank Bank. I appear with my learned junior Tsakani Marilen on the instructions of worksmen's attorneys. And I apologize if I've jumped the queue.
Thank you.
Deputy Chief Justice, Justices, I appear on behalf of the 27th respondent, First Rand Bank, together with my learned friends Ms. Muvangwa and Ms. Machlangu on the instructions of Cliff Decker Hoffmeyer.
Thank you.
Deputy Chief Justice, Justices of the Court, I appear on behalf of the 28th respondent, Standard Americas Incorporated, on the instructions of Herbert Smith Freehills, together with my learned junior, Mr. Mokoena.
Thank you very much.
Deputy Chief Justice and Justices of the Court, I appear with Mr. Marriott and Ms. Nyembe for the 23rd respondent, Credit Suisse Securities USA, in the appeal under case number 27 of 24.
Thank you very much. That seems to be it. Mr. Ngukaitobi, you are aware of the uninterrupted time you have to make your submissions. We will just disturb that when we break for the obligatory breaks for tea and lunch. But other than that, please go ahead.
Thank you, Deputy Chief Justice. What we propose to do is to address 8 topics. The first one is the conduct that we submit amounts to a single overarching infringement or conspiracy. The second is the attribution of that conduct to the named respondents. The third one is the jurisdiction of the Competition Tribunal over what has been referred to as the Pio Peregrini, who were part of the alleged conspiracy. The fourth is the admissibility and the probative value of economic evidence in cartel prosecutions. The fifth is the issue of authority to respond specifically to the 3 banks that say that we did not plead enough facts to show that the named traders had authority to trade on their behalf. The 6th one is joinder. The 7th is initiation. And the last one is the alleged non-compliance with the order of the CAC. I shall address topic 1, 3, 4, 5, and 8. Ms. Hopton will address topic number 2, which is the attribution of the conduct to the named respondents. Ms. Zikalala will address topic 6, which is joinder. and topic 7, which is initiation. To start off then, can I get my minute back? To start off then, which is on the question of the pleadings, and we will not make extensive submissions on this. But it's an important matter of principle that permeates the work of the Competition Tribunal, which is when a party is allowed to bring exceptions or to bring so-called applications for dismissal. What the Competition Tribunal has done in paragraph 23.5 of its ruling is that it decided that even if a party brings an application for dismissal, it will treat it as an exception. That is a very consequential finding, which we will urge this court to embrace. Because what it means is that the ordinary rules of exceptions apply, which means that the only admissible evidence or the only admissible allegations will be those contained in the Commission's pleadings and not new facts alleged by a respondent. That is the first consequence. The second consequence is that that ruling of the tribunal also avoids a scenario in which referral proceedings under Section 49B of the Act are essentially turned into motion proceedings, when the structure of the Act illustrates that these would be dealt with as trials. And it cuts across the entire case because some of the findings made by the Competition Appeal Court are based on new facts introduced under the guise of an application for a dismissal, whereas the normal rule of an exception is that there are no new facts other than those pleaded by the plaintiff, in this case, the Commission. And then the last consequence of it is effectiveness and efficiency of the tribunal proceedings. My learned friends who are all here are competition practitioners. They know how impossible it has become to prosecute cartels because we never get to the merits of the case. We are always held up in procedural objection after objection. This court also knows this because it expressly said so in the Standard Bank dispute involving the disclosure of a Rule 53 record under a so-called review. So it's important that the court gives a judgment that enables the Competition Tribunal to fulfill the objects in the Act, and particularly because there is a policy reason for the expeditious prosecutions of cartels. So that's a framing point about what's in and what's out. Let me then move to my first topic, which is the conduct that we say amounts to a single overarching conspiracy. The starting point is Section 4, subsection 1, subsection B of the Competition Act. That section, as the court knows, prohibits any agreement or concerted practice by firms who are in a horizontal relationship if that agreement fixes a price, whether it is a purchase price or a selling price, or if that agreement divides market, or if that agreement amounts to collusive tendering. This appeal is concerned with the first and the second category of agreements or concerted practices. In other words, those practices that are regarded to amount to the fixing of the price or to the division of markets, which includes division of customers. And the term agreement or concerted practice are important terms to keep in mind. The term agreement is not used in the Act in the definitions section in the same sense as an agreement in contract law. But an agreement in competition law is a broad thing that encompasses a contract, an arrangement, an understanding, whether or not it is legally enforceable. And the concept of a concerted practice is an even broader term because it includes cooperation, coordination between firms, which may be direct or indirect, but the key thing is that it must replace independent action with coordinated or cooperative action. And often it is easy for competition authorities to prosecute a firm that is alleged to be involved in cartel behavior or collusive behavior because the nature of that agreement would be obvious. There would be a piece of paper recording what the terms of the agreement were, and maybe there will only be a few firms involved. Often there will be a bilateral agreement, or maybe 3 or 4 firms. However, and this is what this case illustrates, cartels have evolved. They are now bigger, complex, and transnational. And this case is a classical example of a transnational cartel. Not only do the cartels not respect territorial borders or nationalities, they also do not respect any product in pursuit of profits. The courts would have read many cases of cartels. People are fixing the price of the selling of oranges or the selling of bananas, many judgments like that in the European Court of Justice. But here what we have is something unique, which is that they targeted the sign of our sovereignty, which is the rand, in a perverse scheme driven by profit motives. And perhaps, if for anything else, for this reason alone, the judicial institutions of South Africa are the only institutions across the world that have a legal interest in the prosecution of this cartel. At the heart of it is the rand. To enable competition authorities to prosecute complex cartels that involve multiple participants, European competition law has developed the idea of a single continuous infringement or a single overarching agreement. Our own competition law has embraced this idea as a useful instrument in the prosecution of complex and transnational cartels. It was in this case at the Competition Appeal Court that the SOC idea was accepted and applied. We ask you as the Constitutional Court to also embrace the notion of an SOC as part of our law in line with the developments that have already taken place before the tribunal and the CAC, where the Commission, at least on this score, prevailed. The source of this idea, as far as we could determine, can be traced from the European Court of Justice's judgment in a judgment called team relocations. It's referred to at paragraph 28 of the judgment of the CAC. The facts of that case are not important, but it really identified 3 questions to be answered in order to know whether a single overarching conspiracy exists or not. The first is whether there is a pursuit of a common anti-competitive object, or the effect of that conduct is anti-competitive. So it's this anti-competitive object that is commonly pursued. That's question number 1. The second question is the contribution by each firm to that common object. And the third is the knowledge of each firm of the existence of the plan to pursue the anti-competitive object. And even if there is no actual knowledge, one still needs to ask whether or not it can be said that it was reasonably foreseeable that the firm must have known, and despite that knowledge was prepared to take the risk. These three questions have been distinguished later to constitute really two areas. The first one being referred to as this anti-competitive object, and the second being attribution. In other words, who do you attribute the SOC to? And the first, which is the anti-competitive object, is an objective inquiry, and the second and third have elements of subjectivity, although they are objective as well. On the 25th of March 2025, the European Court of Justice, in a judgment that bears striking resemblances to this case, in a judgment called UBS Group and UBS Commission, we have included that in the latest bundle of authorities that was submitted yesterday. It is at page 11847, delivered 3 months ago. The European Court of Justice, where it dealt with the manipulation of euro-denominated government bonds, and if you read the judgment, it takes the same format as the currency manipulation in the instant appeal. At paragraph 923 of that judgment, this is what the court said in relation to the first element of an SOC. The condition relating to a single objective requires that it be ascertained whether the elements characterizing the various instances of conduct found have an identical object or identical anti-competitive effect, and consequently form part of an overall plan as a result of their identical object distorting the normal pattern of competition within the internal market. In the EU, they call it the internal market, but that's not relevant for us here. What's important for us is whether you can say from the pleading, you can discern a pattern of conduct that pursues an identical object or has an identical anti-competitive effect. In doing so, at paragraph 925, there are several factors that you should take into account. Number one, the nature of the infringement. Number two, the fact that the practices that have been employed in that infringement are similar. Number three, the fact that the goods or services are similar. And number four, the identical nature of the means of implementing the cartel. And number five, sometimes the identical geographical scope of that practice. One factor that is not in the judgment, but which we would add, is not only the geography, but also the period, the time in which this conduct took place. Not all of these factors need to be present, but the court must assess them cumulatively. What we stress in this case are these factors. There is a use of the common currency pair. It's the dollar and the rand. There are common participants. You see the same names over and over again. There are common features of the conduct. There are 5 distinct types that I will be dealing with. There is also a similar instrumentality, which is the use of the chat rooms, or where there are no chat rooms, the same trading strategies. There is also the same period between 2007 and, as far as we could ascertain, until 2013, although we cannot be sure if it ended, but it's the same period. And then, to borrow from the EC bonds case, similar geographies, the United States and South Africa. What is also important, and again, this is a defense that comes across from many of these banks, it is not necessary to find that each bank participated in every form of conduct. It's not necessary in order to come to the conclusion of an SOC. it is not even necessary to conclude that each bank knew every facet of the SOC. It is also not necessary to find that each bank contributed to every form of the misconduct. One conducts a holistic assessment. What the ECJ judgment also finds in Eurobonds, which is paragraph 991 and 992. And in that case, the traders said to the court, my specific trader was involved only in 10 of the 900 instances. The court's answer to that was that that is a factor relevant to penalty. It should not be confused with the existence of the SOC. And this is what they say, specifically at paragraph 992. Moreover, it has already been held that the fact that an undertaking has not taken part in all aspects of an anti-competitive scheme, or that it played only a minor role in the aspects in which it did participate, is to be taken into account when the gravity of the infringement is assessed, and if and when it comes to determining the amount of the fine. So if you say, I was there only once, that's not a decisive factor to exclude you from the SOC. It is a factor for penalty. So right at the outset then, we need to stress that the Competition Appeal Court found that the Commission's pleading contained enough prima facie evidence to show that there was currency manipulation involving the rand and dollar currency pair. It also found that the form of that manipulation matched the pattern of a single overarching conspiracy. It was on the second question of attribution that the CAC disagreed with the Commission's assessment. It found that the pleading demonstrated that only 4 banks were involved in the manipulation of the rand that took the form of the SOC. Those banks were BNP Paribas, JP Morgan Chase, HSBC Bank, or HBEU, I think that's their current name, and Credit Suisse Securities, LLC, which is the overseas entity. That being the 2nd, 3rd, 14th, and 23rd respondent. And it's important to stress this point, is that the finding of the CAC is that the pleading contains enough evidence that the rand was manipulated, but it attributes that conduct to 4 banks and not the 27 that were initially cited. The CAC was not the only court that found enough evidence to show a prima facie case of the manipulation of the rand. The authorities of the United States have convicted traders, people such as Cummins, Katz, Ayer, the same players who are prolific here, of the same offense of manipulating the exchange rate involving the rand and the dollar. In asking you to endorse some of the findings of the CAC, particularly on the existence as a fact, as pleaded, obviously the probabilities will still be decided in trial, of the SOC whose object was to manipulate the rand, involving some banks, we also bear in mind that you will be following what other jurisdictions have already done to enforce competition laws in the prosecution of cartel activity, which involves the manipulation of the rand and the dollar. To return then to the findings of the CAC, we ask you to endorse the findings in relation, let me start with JP Morgan Chase, the 3rd respondent. Those you will find at volume 3, page 276 to 277, at paragraph 125 to 128. What the CAC did was to hold that the third respondent was part of the SOC as pleaded. Why? Because its traders received information from Howes. Howes was employed by ABSA about what is referred to as bid offer spreads. I will deal with that later. That is paragraph 127. Secondly, they found that the traders discussed bid offer spreads with Howes. Thirdly, they found that the traders participated with Jason Katz in March 2012 in these chat rooms. These are the three forms of conduct that the CAC held brought the third respondent within the ambit of the SOC. It is obvious that these three forms of conduct would fulfill the first element of an SOC, the common object to breach section 41B. If the discussion is taking place among competitors, and the court found that these were competitors involved in information sharing and discussing competitively sensitive information. And at paragraph 128, the CAC specifically finds the prima facie existence of the SOC as pleaded. In other words, it endorses fully the pleading of the Commission on the SOC. For the second respondent, BNP Paribas, the findings will be found at page 284 from paragraph 147. This bank employed one of the central figures in the scheme to manipulate the rand. That was Jason Katz. And he was employed between September 2011 to July 2013. And the conduct there is the sharing of confidential information about the rand-dollar exchange rate in one of the prolific chat rooms, which was called the Old Gits chat room. So here what the court does take into account is the format of the SOC, which is taking place in this Old Gits chat room, and the nature of the conduct, which is sharing confidential information about the exchange rates. Those are the two factors taken into account in BNP Paribas. For Credit Suisse Securities, which is to be distinguished from Credit Suisse Group, the findings are at page 280, paragraph 136. And the finding there is that Mr. Hatton, also one of the regular players in the scheme, is implicated because of his participation in the Old Gits chat room, where he shared confidential information about bid offer spreads. Also because of his frequency, he's a regular participant. It was found that the bank that he traded on behalf of Credit Suisse Securities was prima facie a part of the SOC. And then for HBEU, which is page 278, the 14th respondent, they are found prima facie to have been a party to the SOC because of the conduct of Mr. Hatton. Mr. Hatton was at HBEU between 2005 and 2010. I know there is a dispute, but this is the finding. And it says that the conduct in issue, the conduct of Mr. Hatton, is the conduct that is pleaded by the Commission, something we will get to shortly. So in sum, what is the CAC saying? It is saying that the nature of the conduct is the manipulation of the rand-dollar currency pair by banks who are competitors in the forex trading market. It also says that the nature of the conduct is sharing of confidential information, discussion of bid offer spreads, and then it says sometimes we took into account the regular participation of a trader in that conduct. We took into account the reciprocal nature of that conduct, and therefore that conduct was regarded as being prima facie a breach of section 41B. Now, HBEU says that they did not employ Hutton and that the CAC is incorrect in finding that his conduct is attributable to them. But I would like the court to examine closely the pleading. The allegation against Mr. Hutton is at paragraph 65.71 of the Commission's referral. The referral is volume 5. At page 400 and 399. The actual allegation is that Mr. Hutton was employed by and or represented HBUS until 2010 and authorized by HBUS. Then it says, alternatively, its sister company, HBEU, to trade in the dollar-rand currency pair on its behalf. So one should not conflate the pleading with the question of employment. It's really a question of duly authorized. And there is good SCA authority on this. And the judgment is Northview Shopping Center versus Revelers Properties, reported in 2010, volume 3, SA, page 630 at paragraph 28, where it says a pleading that an individual is duly authorized is sufficient to meet an exception objection. There is no need to introduce evidence of the authorization. And therefore, it becomes an onus of the respondent to say that there was no authority. But the pleader initiating proceedings cannot be met with an exception objection where they use the phrase duly authorized. So that is the case against HBEU. If they did not employ him, that is not the same thing as saying he was not authorized to trade on their behalf. One must remember, these are sister companies. These are companies in the same group of companies. It's not as if these are companies that have nothing to do with each other. So we submit, therefore, that the CAC was correct in interpreting the referral affidavit as disclosing a prima facie case of currency manipulation that took the form of the SOC. But was the CAC correct in limiting the scope of the SOC only to these 4? I want to show that had it not been for manifest errors of law, the CAC should have extended the scope of the SOC to more banks than it did. So what is then the scope of the COC? What is the correct scope of the SOC that we ask this court to embrace? As already stated, it is a question to be answered in the first instance by focusing on the alleged conduct, by looking at whether or not there is a common conduct that produces anti-competitive effects that is being pursued by these players. The conduct sometimes can be expressed, such as discussions in the chat room, but sometimes the conduct will be secretive, as is the nature of cartels. And in those instances, it would be admissible and probative to rely on what is referred to as conduct evidence, such as trading patterns or trading strategies, to infer the participation in the SOC. Insofar as the conduct, the affidavit specifies 5 categories of conduct which would constitute violations of Section 41B if established at the trial. The participation in one or more of these acts would demonstrate, we submit, prima facie and objectively the common object to manipulate the currency. Conduct number 1 is sharing of information on bid offer spreads and colluding on the spreads. Now, the court no doubt has gone through the referral. It would have noticed that this is the most common form of the collusion. And it is also most common form even when you read the EC bonds case. What the spread is, perhaps can be explicable by an example. If you are a buyer of currency, a customer, what you are trying to do is to buy the currency for as low as possible. But if you are the seller, you are trying to sell for as high as possible. So for an example, you could say that as a buyer, I'm only prepared to pay R7.20 for $1, and that's the highest amount you would pay. But the holder of the dollar, the seller, could say, I am not prepared to go below $7.30, and that is the lowest. Now the difference between what the buyer says and what the seller says is what is called the spread. And in the example that I've given of $7.20 and $7.30, the spread would be 0.10. Now you could see from the example that I've given that this is highly sensitive information because only you as either the buyer or the seller know your spread with your customers. So when we as competitors share the spread, we collude on it, we impair competition because it amounts to information sharing or price fixing. And this is not a controversial topic. The CIC has itself made this finding that sharing information on bid offer spreads is collusive conduct, prima facie, that calls for an answer in respect of the 4. And the tribunal has also made the similar findings. There is the instance at paragraph 119, which has generated a lot of heat. But it is also illustrative of the problem of information sharing on spreads. And it is in relation to Standard Bank. And that is at volume 5, page 416, where the allegation says, on 1 October 2012, Taylor was employed by Barclays Capital. I know that Standard Bank says he was not employed by Barclays Capital, but it's part and parcel of the problem of anticipating a trial in motion. But the allegation is that Taylor was employed by Barclays Capital and Brownrigg was trading on behalf of Standard Bank. But the allegation says, on 1 October 2012, Taylor and Brownrigg were participants in an implicated chat room in which the following communication took place. Taylor inquired what quote Brownrigg would show a top customer in 25 and 50. Brownrigg responded by telling him 50, 100. Now this comes to this question I was talking about information sharing. What the two, these are competitors. I know that Mr. Sinton says Barclays Capital is not a competitor because it doesn't engage in Forex, but that's a matter for the trial. But what I'm illustrating by this, it appears benign when you first read it. But when you actually examine what are they talking about, they are talking about a customer as competitors, about what price would be offered to that customer. It's a classic instance of price fixing because what they're doing is they are making available information that ordinarily ought to be confidential between them and their customers. And this is the core problem of cartel prosecutions. What competitors ought to be doing is to win market share, which means winning over customers. But when they're busy discussing what price would be offered to the customer, that's a classic instance of price fixing. It's removing the veil of secrecy and the trick of competition with transparency. And it's doing what the definitions say, which is replacing independent action with coordinated action, which is what Section 41B at its heart is about. The second category is the coordination of trading activities. What the banks, and you will see this, the allegations on the first strategy are at paragraphs 95 to 119 of the pleading. In relation to the second strategy, which is the coordination of trading activities, you will find them from paragraphs 131 to 159, pages 419 to 423. So what we mean here about coordination of trading activities is actually a very simple thing. The banks would share information about future trades. I will be placing this trade at X time. And then sometimes they would intentionally hold back their trades. Say, I won't be trading. I want to allow you to trade instead. Or they would put in a trade and then pull it back in order to allow someone else to trade. Now again, this is a form of currency manipulation. It is a breach of Section 41B, pulling back a trade to allow a competitor to trade in your stead is market division. You are dividing customers, you are allocating customers. And customer allocation is prohibited by Section 41B. It's the second of the three instances that are expressly stated in the Act. The third category is what is called coordination of trading at the fix. So this requires a little bit of explanation because it's technical. I hope Professor Chris Malikane will forgive me if I botch the lectures he has given me on the subject. But the fix is the price of each currency determined on that specific day, published on the Reuters platform. So on each day, the price of each currency is published on the Reuters platform. This is sometimes referred to as the benchmark exchange rate. And it's commonly used primarily by institutional investors. But the way it's calculated is that it averages...
Sorry, Mr. Wait, so just go back there where you were explaining it.
Yes.
So I don't want to miss you there. Sorry to interrupt you.
No, that's fine. Let me start at the beginning then. So the third category is the coordination of the trading at the fix, FIX. That's different from FX, which is for Forex, but this is FIX, trading at the fix. Now, what is the fix? The fix is the price of each currency. The rand has a price today. It will be published at 4 p.m. by the Reuters platform. And every other currency has a price. They will say, if you have dollars, you want to buy rands, this is the price. If you have pula, you want to buy rands, this is the price. Everyone, there's an exchange rate that is published for every currency. And it is sometimes used as a benchmark exchange for each benchmark exchange rate. And the people that tend to use it primarily are institutional investors, like your pension funds, because they don't like the volatility of the currency. So they want something predictable. So they will say to them, I've got this money, I need you to go and buy me dollars at the fix. So in other words, the rate you must use when you buy dollars is the rate that will be published at the fix at 4 o'clock. And I will know what the fix is because it will be published. Now, the way that fix is determined, it averages the trades in that currency that take place 30 seconds before 4 p.m. and 30 seconds after 4 p.m. every day. This is why the traders call this the 4 p.m. fix. Because at 4 o'clock, the price of the rand is published. And then some people use that as a benchmark for when they engage in the trading of the currency. Now, the allegation here is that what the banks were doing, they were coordinating trading in order to influence and control the rate at the fix. So, by pushing volumes, or withholding volumes, you can then influence, because the way it's calculated is the 30 seconds before and the 30 seconds after. So you could create an artificial demand or create an artificial supply constraint by withholding. Now you will see this from paragraphs 169 to 172. And this strategy of withholding quotes was actually quite common among the South African banks, RMB, Nedbank, Standard Bank. And those are the banks we don't have participation in the chat room. So that's the third strategy. It appears complex, but it's actually a simple thing, which is the coordination of trading at the fix. And then the fourth strategy is to manipulate the actual exchange rate. There are different ways of manipulating the exchange rate, and the court will find various explanations. I could identify paragraph 185, paragraph 190, paragraph 234 in the pleadings. And the ways that they used to do this is by putting what is called a fake bid. You pretend as if you want to buy, but you're going to withdraw the bid within a second. It's a fake bid. And then you notify your colleagues that I'm just about to put a fake bid. If you want to match me, you can on the fake bid, but fake bid is one of the strategies. And then they would create what is called focal points. And I'll deal with a focal point earlier because one of the banks goes on about a focal point not necessarily being collusive, but that's inconsistent with the pleading. And the focal point is then the point around which the other competitors would price. It's always by definition collusive. And as I say, some of this coordination, which is the actual manipulation of the exchange rates, did not necessarily take place in the chat rooms. But it did involve our local banks. And that will be evident from the nature of the conduct, which is consistent with the coordination in the chat room. So if you put the chat room here and you put the conduct here, the two actually match. What is discussed is what you see in practice. And that's why one should not be beguiled by this idea, where is my trader in the chat room? This is just obfuscation. And then number 5 is the general strategies to increase market transparency. By the constant sharing of information, there was an information overload among these competitors. At all stages of the trading, from customer inquiries to the actual placing of the trades. So the fifth part, again, the CAC made this finding that there was a general increase in market transparency, which is the opposite of competition. So these are the 5, and you will find this at page 441, paragraph 238 of the pleadings. So these are the 5 core strategies that were used. And as I say, the most common was the information exchange on bid offer spreads. All of these conducts, all of these 5 strategies are prohibited by section 41B. And each participant that took place in it was acting in breach of the Act. And objectively speaking, because of the overlapping conduct and the overlapping product, this was same anti-competitive conduct. So how about the second leg of the test, which is attribution? Ms. Hopton will go into detail about this, but I need to just set out some general principles right now. We've extrapolated 6 factors based on paragraph 992 of the EC bonds case that we say are indicative of this pattern. Number 1, there is a core group that has been found by the CAC to have been involved, and then there is other players. They may be peripheral, but they are part and parcel of it. But there is a common conduct. They are doing the same thing over and over again. Number two, there is an expectation of reciprocity. Now, the reason we say this, there's an expectation of reciprocity, because it becomes important when we deal with bank-by-bank analysis. There is no point in disclosing your bid-offer spread to your customer, to a competitor, if you don't expect reciprocation. It's because they must also tell you theirs. That's the only way the scheme can work. There's no point in saying, I'll tell you mine, because you're just pricing yourself out of the market, which is just silly. So the expectation of reciprocity is another indicator. Number three, this similar currency, and I've said this before, the similar currency, it's rand and dollar. That's why Katz is in prison in America, Aya and Cummins. That's why they were all arrested. Rand and dollar, same currency. Similar period, I've already dealt with that. Similar methods that are used, and then similar geographies, US and South Africa. And these are the factors that we say illustrate the pursuit of the anti-competitive outcomes, and therefore satisfy the first element of team relocations in identifying an SOC. We can then move from these general principles that I've been trying to outline to show how the CAC simply got the law wrong and misconstrued the pleading when it decided to exclude some of the banks from the scope of the SOC, which is characterized by the features I have outlined. The first group of banks excluded is Barmley, Merrill Lynch, Bana, first, 20th, and 21st respondents. Why do we say that the CAC simply misunderstood the pleading? The pleading says that these banks were represented by Shepard and Cook in the chat rooms. The CAC says that there was no evidence that Shepard participated in any of the discussions. This is an error of law. The law does not require Shepard to have been a participant in a chat room. It requires him to have been a member of the chat room. Because one of the strategies that are used to collude is increased market transparency, is information sharing. So by being present in the chat room, he acquires the knowledge. There's no need for him to speak. He's in the room where the collusion is taking place. As for Cook, the CAC held that there was no evidence that he conspired with a South African bank. I need to clarify this right now. Whether he conspired with a South African bank is not relevant to the existence of the SOC, because the SOC's inquiry is the question of the participation in the manipulation of the currency. It is only relevant to the issue of jurisdiction, not relevant to the issue of the SOC. The problem here is that the CAC left the central question, which is whether or not Cook's conduct on behalf of either Merrill Lynch or Barmley fell within the terms of the conspiracy. And this was a material error of law. That question is in fact answered in the Commission's affidavit. The Commission's affidavit places him and Shepard squarely within the ambit of the scheme of the manipulation of the rand. Why? Cook was a member of the Old Gits chat room. He was a central player in that chat room. The CAC itself held that that chat room was the most prolific platform in the design and implementation of the conspiracy. Cook was a regular participant in those discussions and a regular participant in the conduct. If you just take the pleading and you count the number of times Cook appears, it's 40 times. He is either present when the collusion is taking place, or he is himself engaged in the collusion. and he is implicated in all of the different categories of the conduct. The question of Cook's authority is addressed specifically at paragraph 65.6 of the pleading. And it goes back to the question of authorization. We say he was employed or alternatively duly authorized by one of the three. 65.6, Deputy Chief Justice. Yes. Now they say, no, he was employed by Merrill Lynch. That may well be, but it doesn't answer the question whether he was authorized by the sister company. And we have given you SCA authority, and we say that employment is not required to be proven. So Cook brought them within the scope of the SOC. Then there is Australia, New Zealand, ANZ. They are connected to the conspiracy through Mr. Katz and Mr. Tezel. The CIC found that Mr. Katz left his previous employer and joined ANZ after 2012. And the pleading stops the conduct of Mr. Katz in 2012. And therefore, when he joined ANZ in 2013, there is no conduct pleaded that is attributable to him. But what the court has overlooked here is that the commission says that it doesn't know when the conspiracy ended, if it ended at all. So quite probably, the conspiracy proceeded beyond 2013, and ANZ would be clearly implicated through the conduct of Mr. Katz. The pleadings will come from ANZ, and they will tell us whether or not they acquired any knowledge of the participation of Mr. Katz post-2013. And I want to refer here, and I'm not going to read them, to paragraphs 309 to 314 of the judgment of the EC Bonds case, the European Court of Justice, which found that knowledge acquired by a trader in a previous employer can be attributed to a new employer if it can be shown that he disclosed it to that new employer. That's the law. So we can take what you acquired from the old to the new. The CIC then speculated that the commission had access to the investigation record of the US Department of Justice. But there was no basis for this speculation. And then another trader is Tezel. And the court will have regard to paragraph 96 of the judgment, page 267, volume 3. It seems what happened is that the CIC just misunderstood what the commission was saying in this paragraph. The commission says in this paragraph, Madras, Tezel, and Aya were in the same chat room. So Aya is one of the main players in the scheme. Madras is employed by Citibank, which is a leniency applicant, having confessed to its participation in the currency manipulation. So the connection is these two other players, Aya and Madras. And that is why he is then able to cut and paste the communication and place it in the chat room, is because he has access to at least, we don't know how many people, but at least a 3-member chat room that involves Aya and Madras. So we respectfully submit that it seems that there was just a misconstrual of the referral. Nomura, which is dealt with at page 268. That case begins at paragraph 194, page 433, yes. And the conduct begins on the 27th of May, 2010. And the allegations there are that several banks, Nomura, HSBC, Absa Standard Bank, held the rand at various focal points At one point, they held it at the focal point of 7 Rand 57. Later on, it was reduced to 7 Rand 56. And that was a scheme, that is what is in the allegation, a scheme designed to enable them to sell rands, which they did simultaneously to gain USD profits. They also did the reverse simultaneously in order to gain rand profits, which the allegation says weakened the rand. This is clear coordinated conduct. Then there is the date of the 2nd of March, where two instances are cited at paragraph 254 and 256. The first instance is Alan. Alan is a representative of Nomura. He is in the same chat room as Katz. Katz is known to be the frequent player in the conspiracy. He is in jail at the moment for manipulating the rand and dollar. On the same date, he is also in discussion, initially about the disclosure of customer information, but then later on about customer codes. Again, these two are found to be collusive. And then finally, there is an additional player, which is Dempsey. And that you will find at paragraph 114, page 415. Now, Dempsey is not talking to Katz this time, but he is colluding with Howes. Howes is employed by ABSA. ABSA is a leniency applicant. What are they discussing? A bid offer spread, which is the most common form of the collusion. So Nomura is in the SOC. Commerce Bank, the case there starts at paragraph 251, where Dowsey, who is the representative of Commerce Bank, is in discussions with Katz. What are they talking about? They are talking about a customer in the market. But moreover, at paragraph 231, it is alleged that Commerce Bank initiated a focal point. Now, let me just spend 1 second on this issue of the focal point, because the CIC speculates that the initiation of a focal point could have been unilateral conduct, in other words, independent action, if you look at the definition of coordination in the Act. They speculate that this could have well been unilateral conduct. But in that speculation, they misread the pleading. The pleading explains what the focal point is. I want to refer the court to paragraph 185.4 of the pleadings, where it is stated that these focal points, in other words, the point of the trade, so the focal point of today is going to be 7 Rand 56. They are created by coordination. Banks agree what the focal point is going to be. And then at paragraph 187, a focal point is specifically defined as the level of the spot rate at which coordination takes place. So far from being benign, a focal point is collusive. So the accusation against Commerce Bank at paragraph 231 is that together with other banks, it's the leader in the initiation of the focal point. There is no point in initiating a focal point if it is not multilateral. It only makes sense if it is multilateral. Then it is alleged at paragraph 233 that they coordinated a match in the average of the bid and ask price with Investec at 8 Rand 32 to the dollar. This stands to reason. I've already explained this at length. And then again at 234.2, it is alleged that it matched with RMB its bid and ask spreads at least twice. And again, these bids and ask spreads is the most common form. It's really your profit. And so matching it with your competitor is collusion. So we have a problem with the Commerce Bank because the CIC simply made speculative findings that are not grounded on the pleading and simply overlooked the contents of the pleadings. There is also an irrelevant discussion that is introduced around commerce on Mr. Sintin, who was an employee of Standard Bank at the time, and the fact that he said that the Reuters information platform shares publicly available information. But this is a misdirection. This has nothing to do with the Reuters platform. It is true that your actual quote as a bank is put on a screen that everyone else has access to, your actual price. But what is not put there is your discussions with your customers, which is what these banks did, is what they made transparent, is the agreements with their customers. So whatever Mr. Sinton said about the Reuters platform, it is irrelevant to the collusion that took place about bid-offer spreads, about matching, about focal points. Then Macquarie, we must admit here that there is only one reference to Macquarie. It is at paragraph 116. The problem here is that the CIC holds that the conversation between Macquarie and ABSA, and by the way, it's a conversation with ABSA, a leniency applicant, could well have been bilateral. And it's unclear here whether they mean it's bilateral and therefore it's not part of the broader SOC, and therefore it could just be an agreement between two parties. But what that reasoning does is to overlook the nature of that discussion. And I said this is one of the crucial elements you look at in knowing whether an SOC exists, is the nature of the conduct. The nature of that conversation is about bid-offer spreads, which the CIC has found elsewhere is confidential information, and in fact was at the heart of the collusion. And here it was shared between competitors, ABSA and Macquarie. And ABSA is a leniency applicant. So we say, although you will take into account that Macquarie is a one-time participant, when you consider the counterparty, ABSA, when you consider the nature of the conversation, it fits the fact pattern of the SOC. So they are in the SOC themselves. And this is all taking place in the chat room. I want to then spend the next 10 minutes on the local banks. Nedbank, Standard Bank, RMB. Also to illustrate how the CAC misinterpreted the pleading. And one of the most glaring failures of the CAC is the absence of any meaningful analysis of the impact of the trading data. But in cartel cases, economic evidence or trading evidence is as valuable as communication evidence. They focused only on the express communication in the chat room and did not pay attention to the unexpressed conduct. There is a paper that I would refer to the court, which we have, and I'm not going to read them, it's long paragraphs. But the paper appears in the supplementary bundle of authorities at page 12041. And it's called Prosecuting Cartels Without Direct Evidence of Agreement. And what it did is to examine national jurisdictions about the problems that competition authorities face all the time. What do you do when you don't have the smoking gun? You never got the guys inside the room discussing the price. But what you have seen are patterns in the market. You've seen when you go to Pick and Pay, a loaf of bread is 12 Rand 56, Shoprite 12 Rand 56. This 12, what is going on? What do you do in those instances? They say that you should not discard economic evidence, conduct evidence. Sometimes conduct evidence is indicative of collusion. And sometimes it will require an expert to explain these patterns. And sometimes it will correlate with express evidence. So the things you see, they say in the chat room, versus the things you see are happening in the market. Those two sometimes will correlate. But the important point is that you should not discard communication evidence. It's admissible and it can be probative. And we are in an exception stage, justices. We are in an exception stage. We are not in the trial yet. The weight to be placed on the evidence is yet to be determined. So the glaring failure here is the dismissiveness of the economic evidence, when every indication is that this was very important evidence that should have been taken into consideration. But even the CAC itself, in a case called Aranda, paragraph 36 and 37, Aranda is in the bundle of authorities, has embraced the use of economic evidence in the investigation and prosecution of cartels. When you don't have direct evidence, what do? And all you have is patterns of behavior. So we submit here that you should look critically at the CAC's complete failure to meaningfully analyze conduct evidence. Here, what the conduct evidence does show are the same anti-competitive patterns that we see manifested in the chat rooms. Let us start with Standard Bank. I have already dealt with the conversation between Brownrigg and Taylor of the 9th of October. There is an earlier one of the 19th of September 2012. What they were discussing there, Brownrigg and Taylor, is the actual spread, the spread of 0.1. And we now know that the spread is in fact another way of expressing the price. So you have an agreement that is pleaded that they agreed on a spread of 0.1. And secondly, that spread of 0.1 was a spread agreed with the other banks as well. So that is anti-competitive object being pursued right there. But moreover, and this is all express evidence that is contained in a chat room, but moreover,
you said you're going to spend about 10 minutes on the SA banks.
yes, I think I've done fine.
We've reached 11:50.
Oh, yes, sorry.
Yeah.
I thought it was a criticism on me, but it's not. All right, yes.
Is it an opportune time to take the break now?
Indeed.
Yeah, we'll come back at 11:31.
As you please.
So this is the last one on my section.